If it was to be granted, guess what? That is grounds for dismissal of all the charges. Because if the prosecution is responsible for misconduct that results in a mistrial, you're done.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, coming to you with my pearl handle pistol cufflinks, so graciously gifted to me by our content genius, Michael Rivers, who is right behind the camera as we speak, who is responsible for all the words that come out of my mouth. I just work here, man. The lawyers for YNW Melly have asked for a mistrial and made a motion saying the prosecutor created misconduct when they did certain things during the trial and the crime.
They were also saying that because they zoned in on Melly, that and they didn't look up any of those other possible suspects that they say could have done it. You know, the ones they were saying online that basically said confessions, but like that's a common ass thing. That people claim stuff that they didn't do online all the time just to get clout. But there was other ones, them trying to blame the driver too, saying they could have investigated the driver. So that's why they're also saying that it should be a mistrial, because they zoned in on one person and they missed the rest of the investigation, so they didn't investigate it properly, basically.
Cross-examination, or the when they called Miss Holmes, the girlfriend's mom, as a witness. And remember, we're going to go through a little bit of her testimony and then watch what the defense motion.
I don't think that the prosecutors were expecting that either, because that was the prosecutor's witness, and she gave like a different statement than to the police than what she was trying to testify, saying, I don't remember.
Trust her.
Exactly. And then so now the prosecutors were like, well, did you lie to the cops when you said what you said? And she's like, well, it was 5 years ago or however long it was ago. I don't remember what I said. I hope I didn't lie to the police.
Oh, yeah, I've seen that.
I hope I didn't lie to the police. I would hope that I told the truth. So it's like, they don't know which is it. You remember, you don't remember, you lied to the police, you didn't lie, you hope you didn't.
Lying about something.
They're saying basically the prosecutors are trying to say that they paid off the witness, or if it's the prosecutors, I don't know. Somebody's trying to say they paid off the witness, that his girlfriend's mom or whatever, so that she would be like, don't remember what you said, and then they don't have a case.
We'll kind of analyze this and see what does it all mean. But before we get to that, God, I tell you, my grandparents, you guys know all about my grandparents, right? They have created this web OnlyFans business in my basement, and they won't leave the basement, and they're making oodles of money with their foot pics. It's just unbelievable, and they've created just so much trouble for me. I got to get them out of there. So, and I can't leave the house.
What?
He's got to get who out of there?
Did he say his parents are selling foot pics in the basement? What did he say? Hold on. Let me. I misheard that. I don't know what's going on. Okay.
They've created this web OnlyFans business. Motionism. We'll kind of analyze this and see what does it all mean. But before we get to that, God, I tell you, my grandparents, you guys know all about my grandparents, right? They have created this web OnlyFans business in my basement, and they won't leave the basement, and they're making oodles of money with their foot pics. It's just unbelievable.
You guys know all about my grandparents, right? Like, as if we were supposed to know already that his grandparents started an OnlyFans website in his basement,
And they're making
selling getting oodles of money, selling their foot pictures. Old ass feet in his basement. selling their feet pictures. I hope they're paying rent. I mean, well, they're your parents, so I don't think they have to. But
grandparents?
Was it his grandparents? Oh yeah. Well, I mean, that's crazy. That's fucking wild.
And they've created just so much trouble for me. I got to get them out of there. So, and I can't leave the house, so I use eSign.com to get a lawyer to sign an agreement so they can get them out of there with a restraining order. But, you know, eSign.com is a great way to remotely do business, and I use it all the time in my practice. You download.
But I'm wondering, is that a true story about the grandparents, or is it just for the ad?
The app, you get 3 free signatures a month, and you can remotely do business. You can use a power of attorney, you can do it for a restraining order, you can do it for a retainer agreement.
All right,
it's just
this
deal. If it's not eSign. So let's get into this. We reacted a little bit to this testimony, but I kind of want to review it again, and review it in the way of through the defense lens and their motion. Okay, so let's just watch her, because there's some implications here that in insinuations that the prosecutor made that are the basis for the defense motion for a mistrial, and I'll tell you about what that means when we get into it.
Why you came down?
I told you why I came down.
Okay, why is that?
Objection. Asked and answered.
Sustained.
Ms. Holmes, have you ever let me rephrase.
So now the prosecutor's, she's like 2 minutes into this, and she's rattled to shit. She doesn't know where to go with this hostile witness.
Yeah, because she said one thing in her statement, and then when she put her up on the stand, she's saying a whole nother thing. So then she's like, wait a minute, like, how do I, okay, and then the fucking defendant people are their objection, asked and answered every 5 seconds. So she's trying to figure out how to phrase the question to be able to say what she wants to say, but she keeps getting stopped every 5 seconds. So she's like confused and don't know really how to go about it.
She knows what she wants to get in, but the witness is not helping her whatsoever. And there's an implication that she was paid off by the defense. And I don't think there's any evidence that that's true.
Did your daughter ever threaten to cooperate with law enforcement?
Objection.
Did your daughter ever threaten to cooperate with law enforcement? Now, that's clearly hearsay. And there's no exception to that.
Sustained.
Ms. Holmes, did you threaten to cooperate with law enforcement?
Objection. Asked and answered.
Different question.
Why don't you come forward? I want you the question, please.
Ms. Holmes, did you ever make any statements about what happened on October?
No, forget that. She already knew.
26, 2018.
Objection. Asked and answered.
I don't know what statement you're talking about. Rephrase the question to specific.
Ms. Holmes, did you ever make any statements specific to what was happening in the car on October 26th of 2018 prior to the homicide?
Objection.
Thank you. I still come on sidewalk, please.
So
she's really trying to get in any statements that she may have made about what happened inside the car. Well, first of all, she wasn't there. So anything she saw, or not saw, but anything she heard about, you know, the answer to that question requires a hearsay response. I heard this from so-and-so. And if it isn't from Melly saying I did that, then you can't get it in.
Ms. Holmes, I want to ask, were you present when your daughter spoke with law enforcement?
She was 17. I had been present.
No. Do you recall about when that happened?
If she was 17, that had to happen in 2018.
Okay. Without getting into what she said on...
Because it's hearsay, and you can't get that in through this witness.
When you came down to Fort Lauderdale...
All that shuffling of papers is so distracting. All this, airtime, dead air, is shows that she's not prepared.
Fort Lauderdale, was your daughter concerned for Mr. Dennis?
Objection. Calls for a conclusion on part of this witness.
Based on your daughter's demeanor, how was she acting?
Sustained.
See, the prosecution's not getting anywhere with this witness, and how she doesn't know that she's going into this objection buzzsaw, which is really what it is. She needs to just get the witness off and just go on with the rest of her case. But she's running dangerously afoul of the court's prior ruling. Now, keep in mind, they're going to be asking for a mistrial later, and this is why.
When you arrived in Fort Lauderdale and saw Mr. Dennis, did you ask him what happened?
Objection. Asked and answered.
Overruled.
I'm sorry, repeat the question?
When you arrived in Fort Lauderdale, did you ask Mr. Dennis what had happened?
No, I did not.
Nothing further.
All that was completely ineffective.
I have one question.
Yes, sir.
You came here and one of your first... Let me get it.
Objection, Your Honor, improper.
He didn't even ask the question yet.
Excuse me, counsel, you direct your comments to...
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, I feel threatened.
How the... Bruh. Look at this.
Did you ask Mr. Dennis what had happened?
And one of your first...
Yes, sir.
You came here and one of your first...
Yes, sir.
You came...
Nothing further.
Okay.
All that was completely
He
ineffective.
doesn't even get the question.
Yes, sir.
Okay.
You came here and one of your first... Let me get it.
Objection, Your Honor, improper.
He came here in one of your, you came here in one of your first, and then objection improper. He didn't even ask the question yet. The fuck is going on? Improper what? What did he say? You don't know because he didn't finish.
I haven't asked.
Excuse me, counsel, you direct your comments to...
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, I feel threatened.
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Good question. I love a good, when to not ask a question, when to stop asking questions, that is just as powerful as asking the right question, knowing when to quit.
Anything else in this witness?
Yes, sir. Ms. Holmes?
Yes.
You said you feel threatened by
Of
me.
course.
Okay.
Why the hell is she even going there?
Yeah.
This is called balls. That answer to that question affected her.
Yeah, it pissed her off, so she just got back up and potentially fucked up the whole thing, because what he's saying is this is the reason why they might get the fucking mistrial or whatever, is because of the comment that she made right now, I guess, after she got pissed off from the fucking witness saying that she feels threatened by her
ego, and now she's gonna allow her to explain. You don't do that.
You failed to appear for numerous court appearances.
No, you never served me. You lied.
Okay.
You lied to the court.
And with regards
You lied to the court.
I'm fucking
See, she shouldn't be doing this. This is just...
to, did you work in Redding, California?
Yes, I did.
Okay. Material.
Overruled.
And so that was a location you were at.
That's why I was a travel nurse. Yes.
Okay. And in terms of the prosecution, you have been served on various occasions to testify.
You served me a subpoena on November to be the next week, and I was in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in
Never.
February of...
See, what is she getting at? You don't ask questions unless it benefits you. You know, and so this little soliloquy between the two of them is just not benefiting the prosecution. In fact, it's explaining the hostility of this witness, and I don't think it's coming out favorable for the prosecution.
2019.
You never served me. You served me to a location I didn't live at anymore.
Do you recall coming to the courthouse in February of 2019
Objection beyond the scope.
Excuse me.
Anything about the courthouse in
Excuse me. Come
2019?
sidebar, please.
You even went so far as to hire an attorney
Yes, I
to try
did.
not to show up.
I sure did.
And has the state offered you any money?
The state basically has me on a monitor. I have to go to my job with this. It's embarrassing. People think I'm a criminal.
Apparently, what she's talking about is that because the state has asked her to appear, and if you remember, I did a video a while back because they were trying to find them, both the daughter and the mother in this case, and they were having trouble because they weren't showing up for, they supposedly subpoenaed them, didn't show up for subpoenas, so they wind up putting an ankle monitor on her, and she said so they can keep track of where she is, and because she's a material witness in a homicide, double homicide, and so she's like, the state has ruined my life. I mean, she's not the criminal here, and I think her testimony is so off a little bit, just very, very not central to the issue. And think about how that would feel. You didn't commit any crime. You're not really part of this case. I mean, you are part of this case, but you're just a witness. And the state's really coming down on you hard because, they want you as a witness.
And if what she's saying is true, you got to look at it from her side. She's saying that the prosecutors are lying, saying that they never really subpoenaed her, that they may have sent out subpoenas, but with the addresses that they're saying, she didn't live there anymore. So how is she supposed to know about a fucking thing that was sent to an address that she don't live at no more? That's like them sending us something to the, you know what I mean? We wouldn't know. So it's like, if what she's saying is true, and she wasn't subpoenaed, as she was subpoenaed at an old address or whatever, she wouldn't have got it. And them just putting an ankle monitor on her because she had probably moved or something or whatever, and she wasn't getting letters that they were sending to her. Now you got to wear an ankle bracelet because you're trying to flee, when that probably wasn't the case. If what she's saying is true, then I would be like, damn, like, I didn't even do nothing. Y'all got an ankle monitor on me. People thinking I'm a criminal. I have something to do with what happened. Like, the hell?
And so, but that's the only way they can secure her testimony. Because, here's the thing. When you don't show up for a subpoena, they can arrest you. And so, short of them keeping her in jail, that's the least restrictive alternative. In other words, giving her a ankle monitor. But it's still very intrusive for the government to do that to a witness.
When you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, Your Honor. So my question was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued,
Yes.
you're aware that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go over.
All these questions come after him just saying who intimidated you. And look what she's doing. She's intimidating, or trying to intimidate her.
Thank you for the 4th District Court of Appeals.
He had to hire an attorney because she tried to get him disbarred.
She said he hadn't hired an attorney because you're trying to get him disbarred.
No, that's a false statement.
Objection.
Excuse me. Counsel, you're not testifying. Right?
That's some bullshit.
She's asking questions and doesn't like the answers. Is cross-examination 101. And now, so her making that's a false statement. You can't just say shit like that.
Excuse me. You asked a question, all right? That's it. You asked the question.
And so, Ms. Holmes, with regards to that, you hired an attorney.
Yes.
Objection asked and answered fucking 8 times.
And you then tried to get any sort of court order requiring you to be here in court thrown out.
No, what I did was I hired an attorney because you were saying you served me a subpoena that you never served.
And that was found to be valid.
You never served me a subpoena. You never served me.
Oh.
I've never seen a subpoena from you from those addresses that you said you served. Those
So-
are not my addresses.
Your testimony is that you have never been served to appear in court.
All this after that one question that the defense asked. Who intimidated you? The state. And now you learn that she's wearing a fucking ankle monitor. You know, that they're chasing her down with subpoenas. And, you know, and they are intimidating. I mean, she just proved the point.
Sustained. Excuse me, sustained.
And so, with regards to your feeling threatened on that, have I ever any sort of physical violence against you?
No.
Do you have any written threats from me?
It's intimidating. You've intimidated me this whole time.
And
Now.
You're intimidating me right now? I mean, she's proving her point.
And in terms of your participation in this case,
Yes.
you understand that you were served a subpoena to appear here today.
You served a subpoena after you arrested me.
And
You served
you
a
have-
subpoena at the jail when I
and
was
you have-
around.
All this shit should not even come in. You arrested me. You put an ankle monitor on me. If
Of course she's not gonna wanna fucking... I'm done.
that's not intimidation. I don't know what intimidation is. By that one question that the defense asked.
They're saying that she was fleeing from her subpoenas, basically. Well, first of all, if you get subpoenaed to come into court, if you don't show up, you could go to jail, right? So basically, they could arrest her off that already. But in her defense, she's saying that she never got the subpoena. So their whole arrest is invalid because how could she be arrested and for something that she didn't know anything about? She didn't know that she was subpoenaed to go into court. So I'm not saying that she knew. I'm not saying that she didn't know. I'm just saying based off of what she is saying on the trial, okay, where she's under oath, she's saying that she didn't know about the subpoenas. So if we take that into consideration, that she didn't know about the subpoenas, their whole arrest is invalid. So of course she's frustrated because y'all arrested her for not showing up to court that she didn't know that she had to show up to. Then you subpoenaed her again, but to her, it's the first time. So it's like, damn, you had to arrest me and put an ankle monitor on me just to subpoena me to come and be a witness for you. I didn't even know about it at all. So it's like, I don't know, that's crazy.
Do you feel intimidated? Who
I would feel
intimidated
intimidated too.
You got all this shit out that you got arrested. You put an ankle monitor on me. You're making sure that I show up to court. You subpoenaed me, but you didn't subpoena me. I didn't see it. I had to hire my own lawyer. Doesn't that sound like the government just coming down on you? So, if anything, she seems sympathetic now. It wasn't in this clip, but we're gonna watch. Now we're gonna watch the motion for a mistrial. So the judge has not ruled yet on the motion for mistrial. We're just going to watch the defense's argument because they are saying that she violated Rule 8035, which is, you know, the recorded recollection exception to the hearsay rule. And they went over and over and over and over again. And we saw how adverse that this Miss Holmes was to the state. So let's just watch the motion for a mistrial. And if it's granted, which it's not going to be, but if it was to be granted, guess what? That is grounds for dismissal of all the charges. Because if the prosecution is responsible for misconduct that results in a mistrial, you're done.
Sure as I could predict that Tuesday comes after Monday, I made sure.
I do not like that guy. Oh my god. He just put stuff in there that's just unnecessary. He's like, as sure as I am. And his pauses, bro, his pauses for dramatic effect is redonkulous, okay? I am sure. Tuesday comes after Monday. Like, what the fuck?
And I'm sure as a Wednesday. a Tuesday.
To stay up till 2 o'clock last night to get these cases to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do, it advanced a ruse pretext that they were seeking to do so under 8035.
So, essentially what he's saying is that they didn't have the girlfriend. I don't think they have the girlfriend as a witness. I'm not sure about that, but that's kind of what it seems like. So they're trying to use the mom because now they have her under lock and key, right?
And they can't use if the girlfriend's not willing to testify, then they can't use the mom for what the daughter said in front of her because that's hearsay. So it's not admissible.
And they're trying to use a mom to get in evidence that wouldn't otherwise be admissible. And they are trying to pull wool over the court's eyes. And basically, they were able to shut him down. Now, here's the thing. The mistrials only, what's the remedy for prosecution misconduct? Well, you can do one of two things, one of many things, but you can exclude evidence. You can have an instruction to the jury to disregard what the state was doing. But if it's so bad that you can't unring the bell, as it were, then it is grounds for a mistrial.
It turns out that 8035, given the witness's testimony, could not be employed. And so...
And what he's saying, let me grab my rule book here. So what are we talking about here? We're talking about rules of evidence. And it's 8035. Anything in the 800s usually deals with statements of witnesses, and so these are 803 is all the exceptions to the hearsay rule. Hearsay generally is inadmissible unless it falls into one of these exceptions. Hearsay is a statement other than the declarant offered in court to prove the matter asserted. So it's somebody else, not the person that we're dealing with.
Not
right?
the mom.
And so a memorandum or record concerning a matter about which a witness once had knowledge but now has insufficient recollection to testify and accurately shown to have been made or adopted by the witness when the matter was fresh in the witness's memory and to reflect the knowledge. In other words, so there's these text messages by Melly and by her daughter, and it's just inappropriate to have that come in through this witness. So let's continue to watch the defense's motion.
The state then went back to Plan 1, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done.
So, and here's why that's important. If the court's already admonished the state to not do something, and then they do something anyway, and they're trying to, get in the back door, for lack of a better word, that is...
Because not everybody's a fucking lawyer, bruh.
Yeah.
And so it's like, okay, I may have heard what they said, but it doesn't mean that I understand it.
Is prosecutorial misconduct. That's serious. And if it can't be cured with an instruction, can we unring that bell?
But I mean, for real though, if the judge has already told you, the prosecutor, that something can't be admitted into court, and you kind of try and find a loophole that's like still doing what he told you not to do, but you're thinking that you're one up on the judge, like, bro, like, come on.
That's part of the game. You find a loophole. That's
yeah, but it's not though. It's not a loophole if you're doing the same
lawyer.
thing that the judge told you not to do.
But if
You're just trying to find a different way to do it, but it's still doing it.
It's all about loopholes.
And it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise.
Well, how could it be a fucking surprise if you got to put an ankle monitor on the person that you need as a witness? I mean, if you had to arrest her and put an ankle monitor on her, don't you think she's going to be fucking hostile?
That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially tried to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no.
You see what I mean by he
They talk
makes
a
lot of statements that are just like redundant. And it's like you're saying the same thing over and over and over and over again when you could just say it
He
once
says a lot of shit that
and get your
doesn't
point
hit
across.
the longest way possible.
Exactly. He says something the longest way possible, adding little ad libs that you just don't need. Sometimes less is more, bruh. Like, just get your point across, and we
Tell us
won't
what
get
you're trying to
frustrated
say.
with you. The point you're trying to make. It's like, I'm like, trying to be like, okay, where you going? Where you going? I know what you're trying to say, but okay, now you said it. Oh, you're saying it again. Oh, but an even longer way. It's like, come on.
Permissible way to do.
So, the statements of lawyers are not evidence. Okay? So, when she made the statement, well, that's a false statement, you can't, the lawyer can't testify. You can't testify in your own trial. You just can't do it. And so, even if she doesn't get this stuff in, she's trying to taint the jury and give the implication of what's contained in those documents just by inference.
The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so, not only did they do it,
I think one of the implications there that he's talking about is that the defense paid the witness off.
after we raised the issue, they did it after the court ruled
No, because the prosecutor
against the
said
state
it.
and admonished the
damn,
state not to
bruh.
do just that. And they launched into
I
that
swear to God.
pursuit. Mr. Demons has been.
No, mute the mic.
Oh.
Prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the.
Now, here's the thing. Is this judge going to toss out a double homicide because of this? I highly doubt it, but he will have to instruct the jury very sternly if he doesn't throw it out.
Admissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial, this jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't
There's always one more thing.
mind.
lawyers like to hear themselves talk. And
Yeah,
I've
this
always
guy
found the more I
definitely likes
talk,
to hear him
the less
talk.
effective my argument becomes. I like to get in there, get out of there.
Motion for Mr. on strategy.
Yes, it's our motion for mistrial.
This is the second one. All right, go ahead.
Well, it's the second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness.
That is serious. I mean, for her to go down that road without solid proof of it is really damning. And how, like I said, how do you unring that bell? How do you get them to unhear what the jury that is, to unhear what they just heard?
And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, Your Honor's instruction to ignore it, it's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes have been so improper and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh.
But it's hard not to just get up and
Hold on, Your Honor.
because the tensions are high. Tensions are really high in that courtroom. It's a little bit gets lost because we're not participating. But when you're in that, I guarantee the prosecutor and the defense team in this instance fucking hate each other.
Have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text. Couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since. So just to let the court know, there is no factual predicate for the implication, or not implication, the accusation.
And here's the thing: does she really need to go there? It's a circumstantial case, right? So they don't have a smoking gun, for lack of a better word. They don't have a gun, period. But they don't have
right there.
anybody saying that Melly did this.
Not yet.
Or do they?
Portland's
the only one that can do that, right?
Yeah.
By the state that the defense sought to take care of her.
And the same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her in my life.
Thank you. All done, guys?
That just hurts you even
Counsel?
more
Yeah.
for you to make that comment.
Yes, ma'am.
Judge, with regards to that, the statements that were in the
Defend him.
records are what was
Paid
used
them
as
off.
impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it based in
in
the
the
records
background.
and the statements that this witness
Oh, he's
made.
mad. Watch this one right here. Look how mad he gets, and then this one shuts it down. He's like,
He's like, cut it out.
watch.
And the same for me. I met
She
her at the
starts
depot
talking.
and saw her today.
For the record, it was my first time ever seeing her in my life.
Thank you. All done, guys? Counsel?
Yes.
Yes, madam?
Judge, with regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it
He
on
was
the
about to go in.
records and the statements that this witness made and put forth in her Instagram account about this case on that. And so in terms of the forming the questions, Your Honor, it was understood that I was put under very strict and difficult conditions to formulate any question.
And if you stray,
Input stepbrother's dad right there. Dead ass.
outside of those strict conditions, it's prosecutorial misconduct.
Because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their...
Look at the look on his fucking lawyer's face, the white dude there. He looks just like he's gonna pounce. He's just gonna fucking pounce on her in a second.
Hence why the state would be seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible. And the status of this impression that there is a catch-all, we're only trying to seek justice and do good exception to all the rules of evidence. And there is no such thing. If it's admissible, admit it through an admissible procedure. You don't try and end around the court's order and the case law.
When you have an order from the court and you violate it, you have to be sanctioned. And what is the sanction? That's really kind of probably the only issue here. And the judge could say, well, you know what, I do agree with the defense that the prosecutor went outside the bounds of my order, so I'm going to instruct the jury. I'm not going to issue a mistrial, but I am going to instruct the jury to completely disregard any of the remarks surrounding that issue. That's probably
But
what's
it's
gonna
already, but the jury, bruh.
When they say that, they already heard it. Or they
Exactly, the jury already heard it.
is,
It's
like,
already in their
78.
decision process. So it's like you can't take that back. Like
Hey,
you
you
say,
guys don't remember that.
you guys don't even remember that.
Strike that from their memory.
Anybody got that mini black light?
You've been stricken.
What's it called?
He remembers nothing.
What is that light called?
I don't know.
Oh my god.
The Men in Black light.
Yeah, the
Just
one
a
that,
big light.
the flash one that makes him forget shit.
Strike it from his memory.
By coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced.
And really, that's the long and short of it. If they're irreparably prejudiced, so that they can't be fair and the bell can't be unrung. And here's the thing: when somebody gets an instruction, do they really listen to those instructions? Sometimes they do. Sometimes, the research on it is that the instructions aren't that effective. So this has been our reaction to the defense seeking a mistrial based upon the cross-examination, or basically the adverse examination by the state of their witness that's not really cooperative. And, he asked one question and asked her, who intimidated you? And he said that she did, the state did. And, by what? By getting her arrested, by putting an ankle monitor on, by ruining her life, as she said. And she didn't even have to ask another question.
Yep.
But she went down this road, and she absolutely proved the point of the defense. So we'll see tomorrow. I bet there will be a ruling tomorrow morning about whether or not the defense motion for a mistrial is granted. If it is, it's prosecutorial misconduct. The case gets dismissed. I don't think the judge is going to have that much desire to just chuck a double murder case based upon that violation of the rules of evidence. But we'll see. If the court grants a mistrial, the case is over, and they can't retry him. If the court doesn't grant a mistrial, there'll probably be some kind of an instruction, I would bet, and then the state will pick up where it left off. Now, remember, there's an issue about whether Bortland's going to testify.
And he keeps going. It keeps doing his name by Bortland. Remember, he's the one that pointed out. He was like, And don't forget, if you're blood, they replaced the C's with B's. So he's really actually called Portland.
He said that?
Yeah, so now he always calls him Bortland, but that's not his name. His name is like Cortland. Yeah. So he always calls him Bortland. I think that's just so bad. He's like, I live by it.
And
No, his name is Cortland, and look at his cufflinks. They're pistols. His cufflinks are pistols. He's a rider. And his whole logo is stop self-snitching.
Michael doesn't really want me to go into this, but I'm going to go into it anyway. My prediction is he testifies. It's too valuable. It's too eyewitness to not have him testify. I've always thought all along he's going to testify. And, and I made some comments about his statements earlier on that his own interview doesn't come in. But the reason his own interview came in without him testifying is because it wasn't offered for its truth, because it wasn't true. The things that he's saying weren't true. And if it's not offered for its truth, then it's what? Not hearsay. Because hearsay is a statement other than the declarant offered for the truth of the matter asserted. Well, if it's not true, then it's not hearsay. What's going to happen here is they're going to get to a point in the trial, and Bortland is going to testify. That is my prediction. How do they not have him testify? And I think he's cut a deal. And that's just my guess. And I could be wrong. And if I am, we'll analyze that too. But
honestly, though, I think the same thing might happen if the prosecutors offer him a deal. You think that he's not gonna fucking snitch on Melly and say because it's where the ballistics were saying where the gunshots came from. They came from behind the driver's seat, which is where Melly was sitting or whatever. Like the ones that happened inside, they were kind of like it entered from the back of the passenger's head and came out in the front. You know what I mean? That's clearly from the back seat, and it wasn't the other guy because the other guy is dead too. So who else was in the back seat? Melly. So if they get the driver to testify and say what really happened, then
two people know what happened.
Melly and the driver.
Now, if the driver is testifying and he cut a deal, that means he's on the other side. That means he's gonna say what actually happened.
And he kind of could be like, I had to say what I said at first because Melly threatened to kill me too. So he could be like...
Unless they're both in on it, but only one of them pulled the trigger, obviously, but...
I'm just saying what he could say. If the prosecutors really want him to testify, he could, and they give him a plea deal, he could say that the first statements that he made when he freaking took them to the hospital, it was all what Melly told him to say. And he said if I didn't say that, and if I didn't go along with that it was a drive-by, then he was going to kill me too or kill my family or whatever. And then boom, he's pretty much in the clear for whatever he said because he didn't pull the trigger.
If he
But then he'll be fucked over in street life because he'll be
if he takes out
he'll be a Tekashi 6ix9ine. And we all know what happened to him.
If he takes out two dudes, why the hell would he not take out the third dude?
Unless they were working together. But okay, so here's also a thing. They're saying that some I don't know if it's conspiracy or rumor. What's a rumor basically? There's a rumor going around that they figured out why Melly was arguing with the passenger in the front or whatever, because he sent nude pictures to his girlfriend, to Melly's girlfriend. Okay, and they had just gotten into a fight over it or something like that. And I think I don't know. There was another thing saying that the dude beat Melly up. or something like that. But then they were cool after, obviously, because they were together at the studio. But this had recently happened. Like, they had gotten an argument over the nudes, pictures to the girlfriend or whatever. They got in a fight. He beat up Melly. And then they ended up... But I don't see if them getting in a fight over that and then them being cool however many days later.
Because
be hanging out in the
they
studio.
signed to him, though?
I don't know. I don't know that part. But I do know that supposedly they were all living together. They were all like part of like a little group or whatever, that they all had like, there was like 4 cell phones or whatever that they were all sharing communally or whatever that word is. They were basically all sharing the fucking phones. So it was like, they're trying to say that wasn't Melly's phone. That was a group phone that all 4 of them or all of them had, everybody in that house had access to. So they can't, the prosecutors can't say that was it. That's what they're saying. Because all the 2 of them or whatever were on 2 of the phones that were in the car, or was it 3? 2 of them, because the driver didn't have his phone, right? There was 3 phones in there. Melly's and the 2 passengers, right?
Okay, I don't know. I haven't seen that evidence.
Dang. And then,
we should just go back and look at
let's
some more
see.
of the video.
And it's like,
over, right?
Yeah, this one's over.
So he got other ones from other days, right?
Yeah, well, I'm just trying to... He does have other ones from other days. But I'm like, should I play just the court shit, or should I play his...
Just like that.
Okay, hold on. Let me go back. Oh, 1 hour ago, he's got a new one. It says denied. Mistrial denied. Okay, let's look at that.
Let's say 2 things happened. Let's say they weren't able to link the phone up
This is an hour
that
ago.
well,
It's already got
and
1.1K
let's say Portland
views.
didn't testify. They'd have no
like
case.
The other video.
They would literally have no case against Melly. You realize that?
Bruce Rivers, he's the criminal
I gotta turn the AC on now.
Bruce Rivers, he's the criminal lawyer. Bruce Rivers, he's the criminal lawyer. And what he do? And he's gonna react to all the self-snitching.
Is he a real lawyer?
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I am a board-certified criminal defense lawyer, and I'm going to be commenting on the Melly case. This is another Melly update, and we are so graciously gifted because behind the camera is the content genius, otherwise known as Michael Rivers. So we're going to react to the Melly thing. But before we get to that, this is brought to you by eSign.com. eSign.com, a very effective way to remotely do business. Here's the thing. An agreement with somebody, the quicker, is an effective way to make it to the office and remotely do business. We are keeping up with the news, okay? So on Friday, the defense made a motion for a mistrial. And the motion for a mistrial was based upon statements made by the prosecutor in cross-examining Miss Holmes. Or actually, well, they called her, and so it was direct examination, but treating her as kind of a hostile witness. So if you remember last week when we had our little chat, I said it's very unlikely that the judge would dismiss the case based upon the defense motion. It's so rare that that ever happens. And so a judge would like to think that a curative instruction would be enough. And that's what happened in this case. The judge said, I'm going to deny your motion, but I am going to instruct the jury. And that's what he did. So now we have so the trial resumes, right? Or does it? No, it didn't. It didn't resume right away because one of the jurors got sick. Because they were dehydrated. They didn't drink enough water. Well, here's the thing. You know, it's really important, especially in a really long trial like this, that you have enough alternates. So let's talk about what an alternate is. So you have 12 jurors, right? But a lot of times you have 1 or 2 or more extra jurors in case somebody gets sick. So rather than, kick that juror off, they delayed the trial and it started back up again at 1:30. But an alternate juror, they don't deliberate. So they get to the end of the case, you find out you're the alternate.
And does that alternate
you have to go home, you don't get to deliberate, you're not part of the decision-making process. But they're super important because in case somebody gets sick or there's misconduct or a juror can't serve for one reason or another, then the alternate comes into play. Without those, you can't have less than 12 jurors, and you can't have less than an unanimous jury verdict. So what happens is you got to start all over again. So and courts freaking hate that. So that's what happened today. And then in addition to that, a few witnesses testified about cell phones. And cell phones and your digital leash is really what's going to play a huge role in where Melly was and when he was there. And now keep in mind, the only way they can tie that phone to Melly, because it's not in his name, remember, is if they have somebody, like say that that's Melly's number, or conversations that Melly had with other people where he's using that phone, and if they can track it with some of the video that's on. But Bortland, mark my words, Bortland is going to testify. I'd be shocked if he didn't testify. Because with that, let's say two things happen. Let's say they weren't able to link the phone up that well, and let's say Bortland didn't testify. They'd have no case. They would literally have no case against Melly. You realize that? Remember, they've already gotten Bortland's statement in, the false statement in, but they've got nobody say that.
They got the false statement in because it wasn't hearsay, because it wasn't the truth, it was a lie. So it can only be hearsay if it was somebody saying that they overheard what everybody thinks that the truth is, But because it was a whole lie, it's able to be admissible and it's not hearsay. But like I said, basically he's saying, if this dude don't snitch and testify, if he don't testify, then they have no case on Melly. No weapon, no witness, no case.
Well, it's one of them did. So if he doesn't testify against Melly, then they're going to say it was him.
They're going to say it was both of them plotting.
And they're going to,
That Melly had the gun in his hands and did the shooting. So right now, what they have is they have Bortland going to the... But they've got nobody say that Melly had the gun in his hands and did the shooting. So right now, what they have is they have Bortland going to the hospital, creating this bullshit story. And why would he do that? He's covering for Melly or covering for himself. And the defense is going to try to hang that jacket on Bortland. In their opening statement, they sort of spread it out amongst a bunch of people, right? But mark my words, I would be really shocked if Bortland did not testify. I thought that Mrs. Holmes was going to be a little more of an effective witness than she was. She hates that fucking prosecution. She hates the prosecution. Why she hate the prosecution? Because they put an ankle bracelet on her. They had her arrested. They've ruined her life. You remember her saying that? So anything can happen. Anything can happen. We don't know exactly. We're not part of the behind-the-scenes negotiations between Bortland and the prosecutors. But he's looking at life too. So I would be absolutely shocked if he did not testify.
Oh yeah, that's
so,
right.
And keep it.
He is.
he could be getting a death penalty, right?
He could be looking at the same thing as Melly.
That's what I'm saying.
So it's either Melly or it's him.
Yeah, exactly. That's what I'm saying.
Damn.
Like, he could, testify because if it's not him, it's him.
And it's not just jail time that they're looking at. Like, they're really looking at the death penalty because it's Florida. So it's like they not fighting or whatever to stay alive and in jail. They fight, to just be able to be in jail. They're fighting because they gonna die if they don't win. They could.
They could get.
They think they could.
Keep in mind, these digital leashes, all the cell phone towers and the GPS locations of where you are, when you are there, and that's powerful evidence. And it's almost irrefutable. So if you take a look at this poll, which was a live poll, 48,000 people roughly were polled. And now these are people who are heavily invested into this, and so you take it for a grain of salt. But 19% he's guilty. 74% say it'll be not guilty, and 6% say it'll be a hung jury. Way too early to even ask that question. Just way too early. But it is kind of interesting to see where people's heads are at. Because if you remember Friday, that prosecutor got her fucking ass handed to her by the defense. I mean, she did not know how to deal with Miss Holmes, and she was beside herself. I guarantee you, she went home Friday night and had a stiff glass of wine or something. And she was pissed off at Miss Holmes. I'm glad I wasn't anywhere near her when she ended her day on Friday. So, but it is interesting to see people's reactions. So why don't you tell us what you think about our analysis, and tell us what you think. I'm sure some of you are watching the coverage. So let us know in the comments where you think this case is going to go.
They didn't show the court in this one.
These prosecutors aren't dumb. They're a little inept at what they did on Friday, and hopefully, if they had their shit together, it won't.
Basically, announced that it was denied. Okay, here we go. Here's the day 5 trial phone tracking evidence.
Which one did we
This one's 19 minutes long. We watched the ones with the guy, the attorney. The attorney reacts.
Oh, you're doing a different one.
Yeah, this one's with, I don't know, it says Cuff Boys. I don't know who that is, but it was posted 7 minutes ago, and it's showing some of the evidence from the court today. Was it today or day 5? I don't know what day 5.
And all the phone records came in. And Melly's team has been trying to avoid these phone records to come in court for years, since I think literally 2020. But it's finally here, and the cross-examinations are pretty funny. So let's get right into it. If you're new to my channel, subscribe. Follow me on Twitter.
Oh, this guy! I know this guy. I just didn't know his name. Whoops.
Instagram right here.
I like him though.
What just happened here at this exchange with the pen? Or do they not want me to use pens anymore or something?
Emergency room on Friday. She thinks she had food poisoning is what I'm told. And she's back in the ER now as we speak.
2 in addition to her?
Yes.
Okay.
2 more jurors missing? There's 3 total? He seems so happy for the situation he's in. I don't understand. This man is cheesing everywhere.
Oh my god.
You're on a trial fighting for your damn life, and you giggling like this in between breaks.
No, he did not do that.
I think the defense is happy that the motion was denied.
I mean, overall, it's definitely swaying towards the defense, and they've looked pretty good so far, compared to the prosecution that's looked pretty sloppy.
The defense, in closing argument, has incredible fodder and ammunition, no pun intended, to go after the integrity of this prosecution. It is absolutely painful for me to watch this direct examination of Ms. Holmes. It's painful.
The Felicia Holmes direct examination was terrible. That did not benefit the prosecution whatsoever.
Going forward, it was a bad prosecutorial move. Last point, Anjanette, when I was the county prosecutor, if one of my assistant prosecutors circumvented a ruling like that, they would not have a job.
Just more context to show you that the prosecutor really made a big mistake here.
When we broke this morning, one of our jurors, Gary, was escorting the jurors out. He was approached, and one of the jurors had asked him a question. Gary, go ahead. You want to tell us exactly what was said?
Yes. She more or less asked me if she could ask me a question. I said, well, it depends. So the question was, she said, well, what's the status of the mistrial?
You need to have her name on the record and find out how she would have any knowledge of that, because that was never stated in front of them.
I think it was.
Wait, the prosecutor's wrong. A juror asked, what's the status of the mistrial, because in front of them, both lawyers asked for a mistrial right in front of them. Of course they're aware that there's a mistrial that could happen.
Your Honor needs to inquire if she said anything in the media or any coverage of that.
The prosecutor's explaining that she wants to make sure this jury isn't looking at the media, because they're...
Bruh, you said it they said it during court. I'm done. Well, how would they know that it might be a mistrial? Because he requested a mistrial in front of the jury. How do you think they know? She just wants the people to think, oh, there could be, maybe they're looking at social media. Maybe that's what it is. No, they said it in front of them.
We're obviously not supposed to do that at all.
The defense attorney said, don't fucking say mistrial.
So that's where you heard from?
Yes.
Anything other than that?
No.
Was there any other research that you may have done or looked at newspapers or any kind of article about the motion for mistrial, anything like that?
No.
So it looks like the lady from the ER has arrived and they're starting now. So this lady has worked for T-Mobile for 26 years. So we're about to get into the phone records, which is probably the biggest piece of evidence that the prosecution has against Melly.
That means that we respond to subpoenas and other legal demands from various agencies across the United States. Call detail records.
Do you keep information regarding the networks?
Yes.
Do you keep information regarding subscribers?
Yes. So call detail reports will show incoming and outgoing phone calls or text messages made or received by the cellular telephone. So what happens is the phone reaches out to the tower with the strongest signal, which is not necessarily the closest tower. So for example, we can have a tower on top of the building, or we can have one down the street. However, the one down the street might be the stronger signal, and we pick up that call. At that point, it's transferred to our switch, and our switch is what records all the information that you will see on the call detail records.
I didn't know that calls go to the strongest tower, not the closest one. That's an interesting fact right there.
We'll show where the phone is connected to when it's not in use, as long as it's turned on.
Is it in the regular practice to keep such records?
Yes.
Here at this time, the state would offer states 000, state 63.
Any objection? Yes, Judge. Objection?
She just submitted that evidence of the phone records, and Melly's team is going to object to it, obviously, because for months on end, they've been trying to get this evidence not to go in court. So they don't want this phone evidence in court. Melly's team does not want this.
Relevance?
Relevance is the objection.
Objection overruled, it will be admitted. What's the next number?
63.
Overruled. Objection overruled. It will be admitted.
The technology that you...
Melly's lawyer's going to try to shit on the technology.
For identifying locations. How is that verified by T-Mobile itself?
That you would have to ask an engineer for.
So you don't know how that's done?
How it's verified?
Yeah.
As to what tower connected to? Is that what you're asking?
Yes.
So it's done with a radio frequency, is how the towers work. It's a signal.
Okay, so but you were telling us earlier that the phone does not necessarily connect to the nearest tower.
Correct.
It connects to the tower with the strongest signal.
Correct.
How do you know how far the phone is from the actual tower?
I don't.
Is there no way to tell that?
No. Not through me.
Not through you?
Correct.
And how do you know if the tower that the phone connected to is the closest tower or the one with the stronger signal?
That would not be a question for me. You would have to ask an engineer.
He's putting the question out there. How do you know how close the person was to this tower? You really can't even say.
How would you know at what point the signal disparity is strong enough for it to default to the one that's further away as opposed to the one that's closer?
Again, that's a question for an engineer, not for me.
So you have no way of helping us understand any of this information that you just described?
Correct.
You just collect it when you're subpoenaed and you provide.
Correct.
And you're not familiar with the technology of it.
Not the questions that you're asking, correct.
It's not used for identifying the locations of customers' phones beyond the purpose of just billing.
Correct.
He's hesitating. He hesitated a little bit then. He wanted to ask one more question. I couldn't think of what it was.
With regards to these records, are they accurate?
Objection. What's the objection?
Lack of foundation, Chief.
Watch himself.
He said, are they accurate? And he said objection. He said, let's go sidebar.
What is contained in the records that have been provided?
Calls and text messages that have happened.
Is this from the network's perspective?
Yes.
She did admit that engineers would know more than her, but I think her only job is just to explain the cell towers and the phone numbers that were put in the evidence. This guy works for the Homicide Unit in Miramar Police Department.
So what I do is we'll stick with the cell phones or cellular phones or devices of that nature. I do the extraction and the analysis for it. Software and hardware from a company called Cellbrite.
Did you do any analysis of the device?
I did not.
In terms of the extraction of the device, were you provided an iPhone?
Yes, yes.
Prior to coming to court today, did you have the opportunity to review the digital copy of that extraction?
I did. This is the generated report of the generated report of the cellular device that was extracted.
Imagine he breaks it right there.
Yes, sir.
They objected it and go sidebar again. They're going to object to anything with the phone records, boys. Over the past year, there was like 3 or 4 different hearings held just for the phone records. Like they were really fighting these phone records for a while, but...
And you have not analyzed it?
No.
You don't know if there's any relevant evidence on it at all?
That is correct.
Who it belongs to either?
I do know who it belongs to. As far as the contents of it, I don't know.
You don't know who uses it?
I do not.
You don't know who it's registered to?
I do not.
Still putting up the fight that it's not Melly's phone and that it's a group phone maybe. Definitely not a group phone.
To account for the number of steps that someone takes. In addition to these cases, I have several articles. There have been lawsuits about the accuracy of the data that is compiled by this type of app, assessing verberation. And every time she goes to church and comes back, she's taken 20,000 steps because she's going like that. Whether or not this information is reliable is yet to be determined.
Melly apparently took like 1,300 steps when he got out of the car and walked through the woods, and his phone tracked him stepping 1,300 times. His team's trying to show that it could be not accurate.
The technology has advanced to the point of being reliable is yet to be determined. But this court cannot admit it until the state first meets its burden of establishing the reliability of the data. Walks 70 steps. Says who? Says an app. What app? The one in his phone. Is it reliable? We don't know. Why? Because she has not established.
Melly's lawyer is really good. I believe his name's David Howard. He puts doubt in every little thing.
State versus Maximit, which is a 1967 case, which was the earliest time in which I could find a pedometer being mentioned. And at that point, it's important to note this is a well-established technology that's been in use for hundreds of years.
Prosecutor came back with other cases and other facts about the pedometer.
Wearable devices as admissible evidence. Technology is killing our opportunity to lie. The 2019, the iPhone held out from a forensic perspective, and stats and distances registered during walking and running being used as digital evidence.
May I just ask if the state is making the representation that all the cases she's citing to do not require that a witness establish the reliability of the technology? It's just put in?
It has been admitted, and I have some of everything that I'm giving to His Honor copy to you as well.
What a chess game right there, boys. That was a hell of a chess game. Both citing sources and both trying to put forth their argument to the judge.
However, the motive seems to be missing, and I think the prosecution really needs to be focusing on that. I know you don't necessarily need that to convict, but again, I think it will bode a long way with jurors if they want to be successful in obtaining a conviction here.
Once again, I'd like to point out as much as I can, my condolences to the families of the victims that have to go through this. This is like such a shitty situation.
Because even though the predicate wasn't made, the objection wasn't made at the time the evidence was sought to be introduced. The state sought to introduce evidence without laying a foundation. Our objection is objection foundation. We're not making a downward objection to an expert who's testifying. And the fact that that foundation needs to be presented by somebody with expertise and knowledge doesn't make it a downward question. It's a foundation question. That there is a wholesale dump of information coming in through a witness who said, I haven't even looked at it. How do we know that the information in there is relevant? How do we know that the information that has been introduced is not more prejudicial than probative, even if relevant, on a 403?
If the prosecutor brought that guy up and he has no idea what the big dump on the phone is, it could be prejudicial to Melly.
That phone is used interchangeably so much that when you dial with it, it comes up with one of the decedents' name as the identifier. It's in the name of Jamie King, not Jamel Demons. It was retrieved from Jameson Francois, not Jamel Demons.
3 decent points, but I truly believe it's Melly's phone if there was a bunch of pictures on it of him using it. Like,
yeah, but if it was a group phone, he would pick it up and he would use it.
Nobody has group phones.
They all live together. So they all have phones under the same plan.
That sounds crazy.
I'm just saying.
Okay, I can see getting phones under the same plan, but sharing the phone.
And it's not even registered in his name.
What would be the point of a group phone?
Why is your phone that's supposed to be your phone registered in somebody else's name? Is your phone registered in my name?
People
and we're married.
People
is your phone registered in my name?
Yeah,
yes or no? No,
listen,
it's in your name.
Have you ever seen somebody?
Was in my name.
Have you ever seen somebody's phone registered in a different name? Yes or no? Exactly, you have. You have. Hold on. More than once. Yes, you have. Hold on, more than 3, 4, 5 times, right?
No.
Yeah.
Calm down there. Calm down there. Don't bite off more than you can chew, okay? I gave you an inch. Don't take a mile.
Like on FaceTime with people calling him Melly in the text messages and him calling his mom Ma in the text messages. I believe that happened, so.
It was being used.
People were calling him Melly. He was calling his mom. Stop it. It was his phone.
Have y'all ever had a phone registered in somebody else's name, but it was your phone? Not your parents, like a friend.
And people were calling
your phone, and it was your phone.
Calling you by your name.
I don't know. It's not common, but people do it, I guess.
After the defendant was arrested, we have information here that indicates that. It shows the phone being used to call. It shows the saved step data from that very unit after he is incarcerated. It's obvious that it's being used by several other people.
Or Melly's manager just had Melly's phone when he just got locked up and was like walking around with it, like figuring shit out, posting on Melly's social media and shit, like using Melly's phone.
Not only is it being used by others to text, being carried by others, it's in somebody else's name, retrieved from someone else, and this witness has not analyzed a single letter, all the information that's been put in. And a lot of it is going to be prejudicial.
Thank you. The relevancy issue is relatively low, counsel. My understanding, where's the phone located at, counsel?
Relevancy issue is low. Judge is basically saying that it is relevant.
The phone was located, it was taken from the defendant's manager on February of 2019. The defendant was providing the passcode and information via jail calls to his manager to use it on that. And the phone also authenticates itself.
He said there was jail calls of Melly telling his manager the password.
Every single photo that is on that, whether it be a selfie, a screenshot of a FaceTime conversation, or anything of that, goes back to this defendant.
And they have to establish it before they put it in, not after the fact. The Instagram account is being used days after his arrest, up to and including pictures of this very trial last week. This Instagram account is being used and accessible to a number of people.
This team's good, dude. They're really trying to point that other people are on his accounts. Every rapper has like a manager label on their fucking Instagram account. It's a good point, but I'm trying to think of like a jury that doesn't understand rappers like that. Like they could be swaying, yeah.
A public account that several people have access to.
I'm sure you're going to be able to ask those type of questions, counsel. I haven't seen it. You haven't made me aware of it. You're saying it's something more prejudicial to the public. If it is, I'm more than happy to go through one at a time with you and find out. But as far as who used the phone, what was it being done, counsel's saying it's relevant to establish this phone. So I've made my ruling. You've made your objection. So everybody knows where they stand on it.
Your decision whether or not to do that kind of verification?
Yes.
Okay, and you elected not to?
Correct, I did not.
Did you have an engineer review any of the data that you retrieved?
No.
How did you verify that the machine, the Celebrite software that you used, downloaded the contents of the phone in its entirety? How did you go about verifying that?
That is not something I can verify. That is whatever the data that comes from that phone and appears on the software. That's what I have. That's what I can do.
Okay, so you can't verify?
I cannot.
Is there another software that you can use to download the information?
Sure, there's other software.
And you only use the Celebrite?
Correct.
And if you use another software and compare the downloads, that would be one way for you to test it, whether or not the download was complete, right?
In theory, yes. So. Yeah.
Oh, so you did test it on another software?
No, I did not, but this is the only software that I have.
The witness is clearly getting a little agitated with these questions, but it's good questions from a defense attorney. He's trying to put doubt in the jury's mind right now about the cell towers and the system Cellbrite that this guy used to get it, so.
It's not that you had another software available to you that could help to verify the completeness and accuracy of your results. It's that you can do it, but you didn't have that software available to you.
Well, correct, I did not do it, no.
He's annoyed.
Do you know anything about the testing of the technology of Celebrite, its efficiency and operability?
No, I don't. I'm not an engineer for that.
So you, pardon me?
I'm not an engineer for that.
Okay, if that Celebrite did not give you a complete and accurate download, you would have no way of knowing.
That's correct.
Okay, so you're just trusting in the faith. You're just having faith that the Celebrite, the accuracy and completeness of the Celebrite technology, right?
That's correct.
Even though you don't know anything about whether or not it works properly.
Correct.
That was a good sentence right there. God, this lawyer, man, he's pretty good.
So it is your testimony, sir, that you didn't do an extraction from this phone in June and then another at a later date?
I don't recall.
At an earlier date in April?
I don't recall.
Any of your reports that indicate that?
I have one that was completed on February 28th.
February 28th. Okay. Nothing further. Thank you.
You whether or not Cellbrite is accurate.
Correct.
In your training and experience, can you speak on that particular subject?
Objection?
What's the objection?
This witness has already testified that he can't speak.
Just saying.
She just tried to ask him if Cellbrite is accurate when he already admitted to the defense team that he doesn't know if it's accurate 3 minutes ago.
Added data to a forensic download or that wasn't on the phone itself.
I'm sorry, objection?
What's the objection?
You would have no way of knowing that.
Over.
Can you answer one more time? Sorry.
Have you ever had an instance in which Cellbrite has added data to the forensic extraction or data dump that was not on the phone itself?
That was not on the phone. Not aware of. I'm an FBI agent, so employed by the Federal Bureau of Investigation.
This man a Fed. I've never had more people call me a Fed in my life in the past like 2 weeks, just because I point out both sides. Like I point out sides from the prosecutor and the defense.
So CAST, or the Cellular Analysis Survey Team, is a group of specially trained and equipped agents and task force officers who do cellular analysis or mobile device location analysis.
And so when you say that, what types of records are you working with?
Usually records from phone companies or other service providers.
So what's the purpose of historical cell site analysis?
To help with investigations. Sort of mapping software and plots it, and then we'll give you a general area where the device was at the time.
Key word right there. He said general area. The defense can really pick apart this guy for sure.
If a specific person was in a specific area?
No.
Why not?
It's The records I have are just about devices.
So there are limitations to your judgment.
Yeah, absolutely.
You make the objection. So this is an order on the admissibility of expert witness testimony by Federal Bureau of Investigation, Special Agent Brennan.
I think Melly's team is objecting any FBI agent coming up. I think that's what I heard.
Agent testimony regarding the cellular analysis survey team.
Who pulling up right by the damn microphone, bro?
So I believe counsel is trying to say that we are going to object to the admissibility of the counts report.
Anthony Williams' cell phone, as well as Mr. Demon's cell phone. That one was
What
done.
other reports are out there?
The other ones were
She keeps calling him demons, and his name is Demons or something like that. But you say demons in front of the jury, so they think him and they think demon. They think evil.
generated in May of 2022 and immediately turned over to defense counsel, and I have a very different recollection of that. This was listed at the same time.
Right now, Melly's team is fighting for this agent's information not to come up. Are they zooming in on the family members? Come on now. Is that Whoa Vicky? Why the fuck is Whoa Vicky there?
Cast report would be used. She didn't give us a definitive answer. We finally rested on the fact that she was not going to be using Mr. Francois' phone. So it is a little bit of surprise that he's now being introduced at trial.
I think she just said she's unaware that Melly's manager's phone and Wither's phones are going to be used.
It's the same one. It was all done at the same time. I believe, if I'm not mistaken, there was a typo that had to be finished on the spelling of the defendant's name, which is why it was generated at a second time.
So she just said there was a typo. That's why it was delayed.
So he's going to testify. I wouldn't normally admit a cast report. I don't see why it comes in here. I don't see this specifically saying it's admissible. I see it's saying Special Agent Collins' expert testimony in the area of the cellular phone forensics, so he can testify. He's here. You can ask him questions that you want, but I don't believe I'd be letting this into evidence. It's just, he's here. His testimony is his testimony. And it's not clear for me from this order that that's what Judge Siegel anticipated, that the report was coming in.
So he's basically saying that she fucked up submitting her report, but he's going to let the guy testify.
I'm not concerned about the mapping. I'm concerned about the report per se.
All right, here we go, baby. I'm pausing this shit. So Melly and Sack Chaser's phones go all the way up together, all the way down over here, and then all the way over here to at 3:57 a.m. towards the Everglades, where they say, where there's no witnesses and shit went down. You know what I'm saying? On Pembroke Road, I believe.
The specific locations, but rather the towers that are used. I think it's important for the jurors to understand that and have...
My understanding is the defense is objecting to that exhibit. Is that correct?
Yes, Judge. That it's irrelevant. I would also object to the fact that...
It's not relevant?
It's not relevant. It's also referring to Mr. Demon's phone. Nobody's established that number 6. It's referring to Mr. Williams' phone. We've got no testimony that establishes that it's Mr. Williams' phone. Records to the phone numbers and assigning them to people. We have had no testimony or evidence before the court that those actual phone numbers belong to those individuals.
This is the extraction.
That's correct.
Melly's telling his lawyer something, but can't read lips, man. Both sides battling to get these phone evidence in there.
YNWBooking@gmail.com. You have YNW Melly, a Twitter account. You have YNW Melly, an Instagram account. You have
His Twitter, Instagram account, YNW Melly booking email on there.
Melly.Montana, the Snapchat account, which the Snapchat is already in evidence. I'm showing that one.
Ooh, the Snapchat's already in evidence and it's logged in on there.
A Facebook account as well on that.
His Facebook? Alright, if your Facebook is on the phone, is your phone, dude?
That's only by Mr. Demons.
Brings up a selfie.
It's the circumstantial evidence to that effect, but I'm not putting that in evidence that way. You show the portion that shows the maps, and you can talk about the maps and the other things, but leave out the portion that has at the bottom, or like the bottom or top, that identifies Janelle Devin's phone. Which way? Because used by the phone.
Use it by phone number. Okay, that's not a problem.
Ooh, that's actually kind of a W for Melly's team right there. He just said you can't say specifically on the paper that it's Melly's phone in front of the jury. You can just say the phone number, which might confuse the jury. But all right, that's a wrap on day 5. Chess match on battling for the phone evidence to be omitted as evidence. Still, they're putting up the fight that it's not Melly's phone with tons of selfies in there.
Established that it's their phone. You could just say that phone number.
His Facebook account, his Snapchat, his Instagram. He calls mom.
Yeah, but like they said, managers and PA people or whatever, they got access to those accounts too. So who's to say that it wasn't someone else's phone with access to his
like all they need is a login. They don't need his phone for that.
I'm just saying.
All right, well, let's go ahead and take a pause.
All right. What do you think? He said, "What the fuck is this?"